discussions on land redistribution, and this is what we're talking about. The legislation was gazetted on Friday and it was submitted to Parliament for consideration, and I'm still in conversation with Advocate Tembeka Ngcukaitobi about his views on what has happened here. He is of course a lawyer and author of The Land Is Ours. Advocate Ngcukaitobi, thanks so much for giving us more of your time. So we were talking before the break about what has slowed down transformation of property rights in South Africa. And one of the things you say is that we've taken our eye off the ball, and then there have been issues such as corruption, for example, that have bedeviled this process even further. Can you expand on that for us a little bit, please?
Thank you. So just to recap on the, I would say, three main difficulties. So the one difficulty is simply a total failure of the government to do its job. And we should be intolerant of this, particularly in today's era. The second has been what we can say, in summary, has been instances of corruption and inefficiency. And these are not mine. These are reflections of the Director General of the department. These are also reflections from the SIU, which began an inquiry into corruption within the Land Affairs Department in 2018. The third element I wanted to reflect upon is that we should not assume that resolving corruption, resolving efficiency, is the silver bullet. We have to look at the structural framework of the land dispensation as a whole. The reason I mentioned the question of structure is if you look at the three legs to land reform: restitution, redistribution, land tenure. On the restitution side, which is essentially how people get the land that was dispossessed from them, there are three structural problems. The first one is the target date. The date, the cutoff rather than the target. The date that was chosen during the period of the transition was the 19th of June, 1913 as a cutoff date. The reason why that is a structural constraint is because by that period in history, most of African land had fallen in white hands. And so even if you ultimately restituted all of the land taken after 1913, you will still have a substantial number of Africans that are unable to claim back the land. The second structural constraint has been what I've referred to as the over-traditionalization of the land reform process. You know, as Sakina, if you want land in this country, you have essentially three options. One is to get it for free from the government. The other is to buy it in the open market. The third one is to make a claim, a land claim. Of course, very few of us will get the land for free from the government because they will say we don't qualify under the means test. And yet, most of us will be unable to raise the necessary capital to get the land. And that leaves the third option, which is making a land claim. A land claim forces you to identify a particular act of dispossession at a particular time. But it also forces you to appoint a lawyer, a historian, a property valuer, an advocate, and sometimes an attorney. Most of us simply do not have those resources. And so we do not have an easy, accessible administrative system like at the CCMA, where you could go and say, I believe I have a claim, and therefore it must be processed without the judicialization. My own experience, having acted in the land claims court, is that an average claim takes in excess of 10 years to be resolved. And if there are appeals, that can go up to 15 years to be resolved. So we have a combination of problems we have inherited and imposed on ourselves as the new government. But we also have structural constraints in the way the system is designed, which work against the landless.
And just a final question, Advocate Ngcukaitobi, with regard to the implications of this amendment, can you just quickly help us understand and unpack those?
Yes. Now, this is, I would say, on the positive side of the amendment. One is we know it applies to all property, regardless of whether it is land or regardless of whether it is stock. And that could be seen as a positive thing, that there is nothing that falls outside of it. The second thing is that it defines the procedures that will be followed in an expropriation. And those procedures essentially are three. One is the government identifies the property that it wishes to expropriate. It must justify the basis on which it wishes to do so. Thereafter, the government embarks upon this actual administrative process of expropriation. And one must distinguish here the administrative process of expropriation from the judicial process of determination of compensation. And the third leg is the determination of compensation, which will be done essentially by the judges. Where the problems are is that this is still a process largely driven by the state, which is the current problem that we've had. What we do not have is a claimant-driven process. In other words, a process driven by those that are landless. So we have now aligned, according to this bill, the process of expropriation with the constitutional mandate. If you exclude what I said earlier, which is we have created confusion because there is an ongoing process of an amendment. If that amendment is taken off the table, which is what probably should happen, if it is taken off the table, what we have done with the current bill is to show that there is a possibility of identifying certain specific categories of land that can be taken, sometimes with no compensation. But where I think, Sakina, the greatest triumph, if this bill is passed, where I think its greatest potential lies is not in expropriation without compensation, but it is in the reduction of property prices so that expropriated properties can be sold at reasonable prices. The crisis we have is that property is just too expensive. It is even above the so-called market value. So if there is any potential for this bill to work, it will be in enabling the state to acquire property at reasonable terms, which might then open up the possibility of a larger, much more faster land reform program.
Advocate Ngcukaitobi, thanks so much for your time and for extending the time for the interview as well. Advocate Tembeka Ngcukaitobi is a lawyer and author of The Land Is Ours, sharing his opinion on the newly gazetted expropriation bill. And do feel free to let us know what your views are. No doubt we'll have further conversations around this particular topic. Let's take a